Hello, everyone. Thank you for attending our webinar today, Complying with the Revised FTC Safeguards Rule, Lessons from the New York Experience. I'm Jim Shreve, and I'll be moderating this panel today. But before we begin, I have a few housekeeping items to go through. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We'll try and answer these questions during the webcast, but if a fuller answer is needed or we're running out of time, we'll answer them later by email. A copy of today's slide deck is available in the resource widget. You can find additional answers to some common technical issues located in the help widget at the bottom of the screen. Today's webinar is CLE accredited in California for 1.0 hours of general credit, in Illinois for 1.0 hours of general credit, in Missouri for 1.2 hours general credit, in New York for 1.0 hours professional practice, experience and transitional, and in Texas for 1.0 hours of general credit, which is pending. We award CLE based on attendance for the entire 60 minutes. Due to changes in jurisdictional requirements, you'll notice we're no longer using automated pop-up attendance checks. As required, we'll display secret words in 2 multiple-choice polls during the webinar. You'll be required to select the secret word from multiple-choice list. So please respond to these 2 polls to demonstrate your continued engagement and earn full CLE credit. Your CLE certificate will be emailed to you later this afternoon once we've verified your attendance. The widget at the bottom of the screen saying certificate only shows whether or not you've earned the certificate. We value your opinions and appreciate your participation in the course. So again, thanks for attending today. This is a follow-up to our webinar from a couple of months ago where we introduced a lot of the new requirements in the FTC's Revised Safeguards Rule. As we mentioned then, the new FTC Safeguards Rule uses the New York Department of Financial Services, or DFS, cybersecurity regulation as a model for many of its provisions. So although the FTC's rule is new, we have resources to draw from in preparing to comply. And so today, we hope to provide some context for these new requirements in the Safeguards Rule and some experience in meeting many of these more specific requirements under the DFS regulation that may be helpful here. So with that, we have a great panel today, and we're especially lucky to have Shawn Malone of Security Diligence here with us. Shawn, if you wouldn't mind, could you introduce yourself, and then Luke and Libby, could you do so as well?
Sure, thanks, Jim. Again, this is Shawn Malone. I'm founder and CEO of Security Diligence. We're a consulting and advisory services firm focused on information security, privacy, and risk management. Key focus areas in cybersecurity and third-party cyber risk. Happy to be here with Jim and his colleagues from Thompson Coburn, and look forward to a great webcast today. Thanks.
Thank you, Shawn. So I'm Luke Sosnicki. Thank you, everybody, very much for attending this morning. I am a partner in Thompson Coburn's Los Angeles office. I'm a litigator and primarily a financial services litigator. I've spent most of my career defending banks, mortgage servicers, and various other financial institutions and all sorts of consumer claims. I also have a very active data privacy practice, largely advising the same types of clients, including financial institutions, on enforcement and litigation risk arising from their data privacy and security practices. Thank you again.
Hi, good afternoon. My name is Libby Casale, and I'm an associate in the St. Louis office at Thompson Coburn. I am in the business litigation practice area, and I also practice in cybersecurity and data privacy. And now I'll turn it back to Jim.
Thanks, everyone. Yes, I'm Jim Shreve. I chair the cybersecurity practice here at Thompson Coburn. I'm based both in Chicago and in Washington, D.C. And I spent a long time working with many entities on cybersecurity and privacy, but most often financial institutions, both traditional financial services providers, as well as others that are deemed financial institutions under laws like the Gramm-Leach-Bliley Act. So somebody like higher education institutions, who, due to receiving federal financial aid, must comply with the requirements of the FTC Safeguards Rule. So we're going to delve in here, but first thing is we have our first secret word of the day. The first secret word is coffee. So if you could select coffee from the multiple choice menu here, this will be the easiest test you take all day. So just select coffee from the list, and I'll give you a few seconds to do that, and then we'll move on to talk about our agenda for today. Looks like most have done it. Select coffee from the list, and I think we're going to move on here in just a moment. Okay, so today's agenda. So we're going to talk about a few things here. Here are the main areas we're going to talk about. So even if you weren't on the webinar from a couple of months ago, we'll go over a few of the basics of the Safeguards Rule, so you understand kind of what the FTC is trying to do here. We'll also talk about what's happened, what are some litigation impacts and other enforcement impacts you might see from the FTC or from others in this space as a result of some of these new requirements. We'll talk a little bit about what we've seen since this rule was issued in October, and what we've seen from federal regulators, and in more broadly in cybersecurity, how this has impacted the discussion. We're going to go into a compliance discussion among our panelists to go through a few specific areas, and then we'll close with some final thoughts and take some questions from you at that point. So with that, let's start in. So Libby, so maybe give us a little bit of background on what is this new Safeguards Rule, and what does it say? Go ahead.
Sure, thanks, Jim. The Safeguards Rule was promulgated in 2002 pursuant to the Gramm-Leach-Bliley Act. It requires covered financial institutions to develop, implement, and maintain a comprehensive information security program that complies with the rule's requirements. So in October 2021, the Federal Trade Commission announced amendments. So some of those amendments became effective on January 10, 2022. However, some of those provisions do not become effective until December 9, 2022. So some of the amendments to the rule include an expanded definition of financial institution to include entities engaged in activities the Federal Reserve Board determines to be incidental to financial activities, such as bringing finders within the scope of the Safeguards Rule. And it adds provisions such as requiring designation of a specified qualified individual who's responsible for overseeing and implementing the information security program, requirements related to risk assessments, as well as periodic reports to Board of Governors or directors. It also includes requirements related to encryption of customer information over external networks and at rest, multi-factor authentication, and secure disposal of customer information. So some of those amendments, as I mentioned, are not effective yet. They become effective in December 22. So that includes requirements related to designation of a qualified individual, specific requirements related to written risk assessments, although that requirement to perform risk assessments is effective now. However, the criteria mandated by the rule becomes effective in December. Also includes specific requirements related to implementation of safeguards based on risk assessments, which includes provisions on encryption and multi-factor authentication, requirements related to information systems undergoing continuous monitoring or periodic penetration testing and vulnerability assessments, training operational requirements, requirements to perform periodic assessments of service providers, requirements to establish a written incident response plan, as well as the requirement that the qualified individual's periodic reports be given in writing regularly and at least annually to the Board of Directors. So now we'll turn over to our next slide. Also, in December 2022 or 2020, excuse me, there was a proposed rule by the Office of Comptroller of Currency, the Board of Governors of the Federal Reserve System, and the Federal Deposit Insurance Corporation. So after that proposed rule was announced in December 2020, comments were elicited, and then on November 18th, 2021, the Office of the Comptroller of the Currency, the Board of Governors of the Federal Reserve System, and the FDIC issued a final rule. So that final rule requires a banking organization to notify its primary regulator of any computer security incident that rises to the level of a notification incident as soon as possible and no later than 36 hours after the banking organization determines that a notification incident has occurred. The final rule also requires a bank service provider to notify each affected banking organization customer as soon as possible when the bank service provider determines that it has experienced a computer security incident that has caused or is reasonably likely to cause a material service disruption or degradation for 4 or more hours. The effective date is April 1st, 2022, and the compliance date is May 1st, 2022. The final rule applies to the following banking organizations. So for the OCC, banking organizations includes national banks, federal savings associations, and federal branches and agencies of foreign banks. For the board, banking organizations includes all U.S. bank holding companies and saving and loan holding companies, state member banks, the U.S. operations of foreign banking organizations, and the Edge and Agreement corporations. And for the FDIC, banking organizations includes all insured state, non-member banks, insured state licensed branches of foreign banks, and insured state savings associations. So for purposes of this rule, the definition of a computer security incident is an occurrence that results in actual harm to the confidentiality, integrity, or availability of an information system or the information that the system processes, stores, or transmits. And for purposes of the rule, the definition of a notification incident is a computer security incident that has materially disrupted or degraded or is reasonably likely to materially disrupt or degrade a banking organization's ability to carry out banking operations, activities, or processes, or deliver banking products and services to a material portion of its customer base in the ordinary course of business. Business lines including associated operations, services, functions, and support that upon failure would result in a material loss of revenue, profit, or franchise value, or operations including associated services, functions, and support as applicable, the failure or discontinuance of which would pose a threat to the financial stability of the United States. So now we'll turn to comments by the FTC chair. Sorry, Jim.
Sure, and if I could just get one brief comment in there. I mean, some of you, if you're at a depository institution, you may be thinking, oh, we've had requirements to notify our primary federal regulator for years. And I would, under the interagency guidance, which was issued in 2005, and I would note that this is kind of points out the difference between cybersecurity and data security, whereas the prior issuance looked more about did you have unauthorized access to data that might be on your systems, whereas now this is more of a cybersecurity requirement. The new one looks to the systems themselves, where the system's compromised, even if it didn't involve access to the data. So, this more goes to the safety and soundness mandate of the depository institution regulators, the prudential regulators, than that earlier issuance did. So that's one of the important differences, I think, between this issuance and the one from several years ago. So, Libby, you want to tell us about the SEC?
Sure. So on January 24th, 2022, the Securities and Exchange Commission Chair, Gary Gensler, made the following statements regarding data privacy and personal information at the Northwestern Pritzker School of Law's annual Securities Regulation Institute. Said, Congress addressed this issue in the Gramm-Leach-Bliley Act of 1999. The Commission adopted Regulation SP in the wake of that law. It requires registered brokers, dealers, investment companies, and investment advisors to protect customer information, records, and information. It's the reason that, to this day, a lot of us receive notices informing us about companies' privacy policies. More than 2 decades after Regulation SP was adopted, an eternity in the cybersecurity world, I think there may be opportunities to modernize and expand this rule. In particular, I've asked staff for recommendations about how customers and clients receive notifications about cyber events when their data has been accessed, such as their personally identifiable information. This also could include proposing to alter the timing and substance of notifications currently required under Reg SP.
Yes. So on the previous webinar, we talked about that we might see more action by other regulators. And we specifically called out Regulation SP since it's been a while since it was amended. It was proposed for amendment in 2008, and that was never finalized. So here's additional evidence that the SEC is likely to look at Reg SP and possibly amend it. And so I would guess it's more likely than not in the coming months we'll see something coming from the SEC under Reg SP. Another thing I would note, and this is very recent, is that just last week the SEC issued a proposed rule on addressing cybersecurity risks at investment companies and investment advisors. I would note this is not an amendment to the SEC's version of the Safeguards Rule in Reg SP. In that issuance, which I'm not going to go into it in depth because it's 243 pages long. We've got plenty to talk about today. SEC notes that the FTC's amendments to the Safeguards Rule that we're talking about here, and that some entities may be impacted by both rules. The proposed new SEC rule would not so clearly follow the New York DFS model with more prescriptive requirements. It mentions several areas of controls and mandates a risk-based approach with more leeway, which is more like the traditional approach we've seen from financial regulators in this space. To me, this is more of a perceived, filling a possible gap in coverage for cybersecurity. And this is more aimed at cybersecurity than data security. So it's not applying to broker-dealers. It's applying to investment companies, investment advisors. As I said, I do think we're going to see more under Reg SP in the coming months, but possibly the way this looks, it may indicate that the SEC might not follow the FTC's approach with something more prescriptive, but we'll have to see. With that, Luke, could you tell us about some litigation impacts, possibly?
Sure. Thank you, Jim. All right. So by now, I think the litigation and enforcement folks on the call are probably starting to wonder how this might actually impact them in terms of the FTC's enforcement of the rule in light of adopting some of the NY DFS requirements. So one approach is to look at what NY DFS has done, look at what the FTC has done recently under the Safeguards Rule, and see if we can draw some patterns, draw some conclusions, and go from there. So what has the NY DFS done in enforcing its regulations? Well, its first big enforcement action was against First American Title. The short version is First American Title left personally identifiable information on a unsecured website for a number of years. It was actually publicized by a well-known activist that this problem was occurring, and they actually had to go through enforcement actions by a number of agencies, including the NY DFS. To focus on that, and this is probably the first trend that we can kind of identify, the NY DFS's focus was mostly on the inadequate response and or inadequate risk evaluation that the department felt had occurred, as well as a failure to follow internal procedures that they again took issue with. The second and third are interesting, both actually phishing-related enforcement actions. Both Residential Mortgage Services and National Securities Corporation were enforcement actions relating to, I don't want to say standard because I'm not sure there is such a thing, but more run-of-the-mill phishing attempts. Both also focused on inadequate response and what the department felt was not adequately characterizing or evaluating the seriousness of the risk and not investigating to the department's satisfaction the actual breach. The first resulted in a $1.5 million penalty, the second in the $3 million penalty. One thing I'll add about the second one is the department specifically identified the failure of the company to maintain multi-factor authentication as one of the reasons that they felt that the security was inadequate. And then again, the department also took particular issue with the fact that they believed the investigation and response was inadequate as well. So the big takeaway is really the department has focused on, and this is something that loops back to something that Jim said, really a soundness and internal control type analysis of whether the institution is complying with its own internal policies, whether the institution is adequately following its own internal protocols to adequately and sufficiently evaluate the risk and the seriousness of what's going on. So what about on the FTC side? Well, on the FTC side, the most recent enforcement action under the Safeguards Rule was against this entity, Ascension Data and Analytics. And that was more closely related to, or more similar to, the First American situation than it was the phishing attempts of residential mortgage and national securities. Ascension Data and Analytics was a contractor to mortgage companies, provides mortgage analytics services. They themselves hired a third-party contractor to process the data, in effect, to OCR the data to make it more easily, work with it more easily. And it was that third-party vendor that used a cloud-based unsecured server to store this data and allowed it to be publicly disseminated. And interestingly, the FTC noted in the consent order that among the incursions that were able to be traced, a couple came from Russia and China. The FTC, like the department, focused on issues of internal controls. In this case, the issues were mostly focused on, unsurprisingly, third-party oversight and internal controls relating to specifically evaluating whether third parties were complying with the data security standards that they represented to the company that they would comply with. So what are the kind of takeaways that we can discern from what the department and what the FTC has done so far? Well, the first question is whether the FTC's adoption of New York DFS type prescriptions means more enforcement in general, and the answer is likely yes. Obviously, a good playbook for an enforcement action that the FTC can use to specifically identify breaches likely means the FTC is interested in pursuing more actions along these lines. The second question is whether the FTC is going to venture into the intrusion-based type claims or type enforcement actions that the NY DFS has seemed to really have taken an interest in. It's yet to be seen, although again, I mean, in adopting specific standards, for example, relating to multi-factor authentication, there's certainly a lot more opportunity there, I think, for the FTC to pursue those types of claims. So punchline is yet to be seen, but certainly indicative that the FTC is intends to take a more active role in enforcing these types of issues. So how does this affect the private litigation side of things? And there's a number of ways. For purposes of this webinar, I wanted to focus primarily on two. The Safeguards Rule is itself not privately actionable. Unfortunately, I hate to spoil it, but that does not mean that it's going to have no effect on private claims relating to data breaches. For a couple of reasons. One of the effects that the new Safeguards Rule is very likely to have is with respect to the applicable standard of care. And let me explain that a little bit. Data breaches at this point, or data breach litigation at this point, is fairly ubiquitous. There's a new case being filed almost daily, if not certainly weekly, if not daily, relating to an entity who was the subject of a data breach and is now facing litigation risk. Many of these lawsuits are still being brought under common law theories like negligence. And again, for the litigators on the call, to bring a negligence cause of action requires the plaintiff to establish an applicable standard of care, and then it's breach. And that's where these types of regulations we've seen really fit in. The plaintiff bringing this sort of action in establishing the relevant standard of care that the defendant entity allegedly breached now really has a menu of options to plead in terms of what that plaintiff believes the defendant did wrong. It's no longer kind of a nebulous, the defendant failed to follow reasonable security practices, but now there's specific things that a plaintiff can identify based on this regulation that the defendant likely failed to do. We've also seen this and are likely to see it more, not just on a common law theory, and not just a common law standard of care, but statutory as well. And I've quoted some language here from California's statute, the CCPA, soon to be the CPRA, that grants a private cause of action for data breaches based on a failure to maintain reasonable security procedures and practices. And again, in defining that, that's where even non-privately actionable standards and regulations are really relevant, because they define what exactly reasonable security in particular situations might mean. So we do expect this to start, the regulations themselves, to make their way into private lawsuits as relevant and in many ways defining the applicable standard of care. The second way that this might affect and is likely to affect private civil litigation is simply in the records that complying with these requirements, including breach response requirements, are likely to generate. In the last 2 years, a number of federal courts have sent some pretty strong warning shots to institutions, including financial institutions, that things like data breach response investigation reports may not be privileged. In two notable cases involving Capital One and Clark Hill, the courts found that incident response reports needed to be produced to the other side in civil litigation because they were not subject to the traditional privileges that at the time the defendants thought most likely applied. The financial institutions' compliance with these regulations creates a lot of internal documentation, and under a couple of these decisions, that's all going to be fair game in civil litigation. So financial institutions are really going to have to consider that and carefully think about it when they are responding to incidents, documenting it, and then complying with the regulations themselves. And with that, I will turn it over to Shawn.
Well, thanks, Luke. Can you hear me okay?
I can.
Okay, great. Thanks for that, Luke. I appreciate your insight into the litigation area. So I'm going to spend a few minutes now talking about some of the new safeguard rule elements as they've been published in the final rule. And as Jim pointed out at the beginning of the webcast, there seems to be a fairly close resemblance to the New York DFS regulations that came out a few years ago, with some wording changes here and there, and in some cases, wording that's almost identical to what New York DFS has published in certain control areas. So let's go through the few slides here that covers the important areas to think about in the final rule. And as we go along, I'll kind of point out how similar, or to the extent that they're dissimilar, to New York DFS. So in the program governance and reporting area, we've kind of highlighted these 6 areas. The heart of the final rule are the first 2 bullets here, the written information security program and the risk assessment process. Similar to New York DFS, there's a significant reliance on organizations to document their security program and the elements that cover that program. And the written program documents should be tailored to the size and the complexity, type of financial activities that you're involved in, and the kinds of consumer data that's being collected. The risk assessment process is a key program element used to define the information security program. It's really the basis for what you're going to spend your time working on. It needs to identify reasonable, foreseeable, internal and external risks to compromise of consumer information that you may collect or hold. The risk assessment process needs to also include criteria and define that for the evaluation and categorization of the risks and threats to your organization. What the assessment outcomes look like of your current posture, your security program posture, and adequacy of existing controls that you may have in place. And lastly, the risk assessment process needs to identify the risks and how those will be either mitigated or accepted. And if they're accepted, what's the rationale, the documented rationale behind those. So a written information security program and a risk assessment process are 2 key elements that really kind of set the stage for complying with the final rule, very similar to what you see in New York DFS. Incident response program is another key governance control, and the final rule from FTC calls it an incident response plan. I like to use the term program because a plan or plan document is really just one element of a multifaceted incident response program that includes, of course, that written plan with key goals and objectives, the process and the procedures by which you respond to an event within your organization, all part of the plan document. Roles and responsibilities and decision-making authority as part of a named incident response team. How you communicate both internally to key stakeholders, but also share information that's needed, shared and communicated outside your organization as appropriate. Remediation requirements, how the incident gets documented so that you have a formal record of what occurred, how you responded and who responded. And of course, it's important to go through a post-incident or post-mortem phase where you review how well you responded to the incident, what things worked, what things did not work, all part of an overall lessons learned activity, which then can help to update the incident response program documents, including the written plan. And then service provider oversight. The final rule does talk specifically about service provider oversight, both from selecting the appropriate service providers or third-party vendors to support your business, and how you go about selecting those relative to their ability to protect information, relative to the final rule, very similar to what New York DFS calls out in their service provider oversight section. This also includes management of the relationships on an ongoing basis, appropriate contractual requirements, clauses, and performing assessments on those service providers to ensure that what they're relaying to you relative to their program and protection of data is actually in place and effective. In the oversight and reporting area, the final rule specifically talk about, excuse me, a qualified individual to be responsible for the information security program. New York DFS specifically calls out a CISO, a Chief Information Security Officer, or designee. The final FTC final rule labels it a qualified individual. That's a defined term within the final rule. And it can be either internal full-time employee that is a CISO or has a security leadership role, or it could be a third party that provides that role on a contract basis. If it's the latter, the final rule does specifically point out that somebody within your organization that's an employee is to provide some oversight of a contracted qualified individual. The final rule also talks about that qualified individual leading and providing leadership for periodic reporting to the board or an equivalent body if there is no board within your organization on a periodic basis and at least annually, very similar to New York DFS. New York DFS took it a step further and not only required this type of periodic reporting to a board or a board equivalent, but also filing an annual assertion with New York DFS proper on the compliance with the program. The FTC final rule does not go that far, but does require you to make sure that the board is part of information security and cybersecurity program from an awareness and stakeholder standpoint. So, some thoughts on program structure and methods. And I've grouped the 5 key ones here that are part of the FTC final rule. Similar to New York DFS, these are all areas that the DFS is called out within their regulation as well. So, well, I didn't state this up front. This is a good time for me to point out. If you are obligated under New York DFS Part 500 and you've assessed your program against that regulation and are in good shape there, meeting the FTC final rule that we're talking about today should be well in hand. So formal change management, we know that change management that's handled in an informal way and not documented and reviewed and approved prior to changes being implemented is one of the key ways that security vulnerabilities can seep into a program and into an organization. So the FTC final rule does talk about change management and making sure that that is formally handled in a way that's effective, documented, and defended, and allow for organized backouts of changes that might not work as planned. Secure application development, both final rule from the FTC and New York DFS talks specifically about making sure that application development that's done in-house is done in a secure manner, including testing, to make sure that any code that gets deployed is free from security vulnerabilities as possible. Asset management program, the final rule does talk about making sure that you know what your assets are, and that includes data, personnel, devices, systems, and facilities, so that you have a documented asset management program so you know where those assets are. In the case of devices such as workstations and laptops, who are they issued to and where are they located? Records management. The final rule talks about specific disposal criteria around records and actually call out, unlike New York DFS, actually calls out a 2-year retention period or other criteria that might change that retention period. New York DFS doesn't call out a specific time period, but it does specifically say that secure disposal shall occur once business records and documents have expired relative to their useful life. This really kind of points to the need for a formal records management program in your organization, and in order to assign retention periods to different types of documents based on business need and local, state, and federal regulations relative to the types of records that you have. This includes not just business records for your core business, but of course records to support employees and consultants and contractors relative to HR information. And then training. Security training and awareness programs are a key component of any program, and certainly have been called out here in the final rule as well as New York DFS. And there's some specific language in both regulations relative to general security training and then additional training that may be required for those personnel that are in security roles or charged with managing and operating security technology. And certainly users that have administrative or privileged access should be obligated to undergo some additional training relative to those types of accesses. Key safeguard controls that are called out in the final rule, as well as New York DFS access controls, specifically including language relative to least privilege access, giving users and personnel just the access that they need to perform their jobs, and also what I like to call least data access to just the data that they need to do their jobs, and that typically for in-house applications done at the application level. So RBAC, role-based access control, is a key control here in the security area, and that's certainly called out here in the final rule as well as New York DFS. Encryption of both data in transit over external networks and data at rest. Key provision here, encryption is a key component of a security program today. Data in transit over external networks, that's relatively straightforward today. Encryption of data at rest for new systems is much easier than it's ever been. New systems can be designed to take into account an encryption control in the application and database level. Where it can get tricky and may become an issue for some organizations is when you're operating some sort of a legacy system, perhaps a legacy mainframe, where encrypting the database could cause your application to stop working. And now you're faced with an expense and resource time relative to redesign and recoding of an application, a legacy application. New York DFS and the final rule in this case do allow for provisions for other mitigating controls for encryption of data at rest, as long as they're approved by, in the case of the FTC final rule, the qualified individual, or the CISO in the case of New York DFS. The initial proposed language for New York DFS years ago did not have that provision. And that was one of the key comments that New York DFS got back. I believe that in reading some of the comments in the Federal Register, it was similar with the FTC final rule, that encryption at rest across the board without any ability to use mitigating controls for those legacy systems is problematic. So good to see that in there, and it allows a little bit of leeway for those legacy systems to be able to be protected in other ways. Monitoring and logging, key component of an information security program, and that should include access control as well as continuous monitoring for threats. They specifically call out continuous monitoring in both New York DFS and again here in the FTC final rule. Continuous monitoring is a bit easier to accomplish today with things like SIEM, security information and event management systems, as well as endpoint detection and response systems such as those offered by CrowdStrike and others that actually not just look for a malicious code, but also spawning of software that shouldn't be running on end devices and servers. So monitoring and logging, including continuous monitoring, key part of the final rule and is used by many organizations in today's information security programs. Testing and periodic assessments. The final rule does talk specifically about vulnerability assessments and penetration testing, similar to New York DFS. Those should be part of overall assessment, self-assessment programs within your organization. Typically in the financial services arena, penetration testing and vulnerability assessments conducted internally on a periodic basis, say quarterly, is typically what we see today, but also once a year going to a qualified third-party security firm to perform those by that third party as part of an additional check and balance in this area. Risk assessment review. So risk assessments are not a once-and-done activity. As I said, it's a key component of programs today and is shown prominently in the FTC final rule, but risk assessments need to be updated on some periodic basis. So I included that here in the periodic assessment section of my slides. And of course, service provider assessments, part of service providers and third-party vendors, making sure that you're assessing them to make sure that they're continuing to maintain a program as good or better than yours to protect the information that you entrust them with or you give them access to. And finally, a couple areas for consideration. Neither the FTC final rule nor New York DFS specifically called out patch management or vulnerability management as a broader term, which is an important area. You may remember the Equifax breach of some years ago, which was probably the largest and may still be the largest that we know of. That was largely a program governance and a failure to implement patches in a timely fashion. The patch management or vulnerability management, as it's sometimes referred to, is a key area that is inferred in the FTC final rule and New York DFS, but not particularly called out. And then breach notification. We know that there's a proposed additional requirement as an add-on to the Federal Register or the FTC final rule. The public comment period on this breach reporting requirement just closed earlier this month, but the proposed language was reporting to the FTC of a breach within 30 days of the event that affects at least 1,000 customers or more. So we may see that come to fruition or some version of it. It has not yet happened since the comment period just closed, but thought I would throw that out there as an area to keep an eye on. And that's it. That's a kind of a very quick rundown of what's in the final rule. And I'll turn it back to you, Jim.
Well, thank you very much, Shawn. So here's our second secret word of the day. The second secret word is lunch. So please select lunch from the multiple choice menu here. Go ahead and select that, and then we can move on. You have to select this so you can get your full CLE credit. Go ahead, lunch from the list here. And we will then go on to a brief discussion period here to delve into some of the more important points under the new Safeguards Rule and some of the lessons we can learn from New York DFS cybersecurity regulation. I'll give you a few more seconds here, just a few haven't done it yet. Okay, pretty close. Okay, we're going to move on. Ready? Here we go. Okay. So let's have a discussion. Some of these particular points here. So I'd like to start off with a question to Shawn. So you've been doing this for a long time. You've advised many DFS regulated entities in going through this compliance process and dealing with a lot of these specific security control requirements. Do you have any tips on how to structure that compliance process to make it go more smoothly? Sort of who to involve or potentially not to involve, who should take the lead, talking with the board, as well as guidance about which specific security requirements that are required under both the Safeguards Rule and under DFS, cybersecurity regulation, might be more particularly difficult and take longer and more money to put into place. Shawn, welcome. Any thoughts? Shawn?
Yeah, sorry about that, Jim. I got bumped off and had to dial back in. Please repeat the question for me.
Sure. No, I was just saying you've gone through this process quite a bit with entities under New York DFS. And so do you have tips about how to kind of structure this process to make it work better, who to involve or not involve, talking with the board, who might hold the purse strings for a lot of these things, as well as maybe some of the specific control requirements we see under the Safeguards Rule and under DFS that may be more problematic or costly to put into place. Any thoughts you have here would be welcome.
Yeah, sure. So, anytime a new regulation comes into being, your organization needs to first take a look at it, make sure that the applicability is appropriate for the type of business you're in and what you're doing. And so, and that typically should include a group of people within your organization representing different departments. In my experience, of course, your internal legal department should be part of your small team that you pull together to go through the regulation, understand what it means from a technology and security control standpoint. There may be some specific compliance-related documentation requirements. So if there's a separate compliance officer or department that would play a role here. In the case of both of the FTC final rule and New York DFS, where they focus some attention on third-party oversight, if there's a third-party oversight group organization, they should partake as well. The board and the senior leadership need to understand that these regulations that come about need to be looked at from where you are in the organization, the type of business you are, and data that you collect, process, and store, and understand that these are areas that may require some resources and some dollars in order to improve or make changes to your program to meet the new regulations. Some of the
Shawn,
I've seen both.
Shawn, I was just going to ask, a lot of entities out there, the information security, IT people, are frequently engaging in tabletop exercises to test systems, test new structures, test for as part of the compliance process. Do you think there could be value in involving some of the board and senior managers in those tabletop exercises, both to prepare them and as well as to make them maybe see what the money and time and effort is required here?
Yeah, I just talked about an incident response program on some of my earlier slides, and certainly tabletop exercises and mock drills are an important component of that, and they should include senior leaders, including up to and including board of directors or equivalent governance bodies, so that they can understand what's involved and what role that they play relative to protecting not only the organization but the data that they're entrusted with.
Okay. Are there particular control requirements that have been more difficult to implement under DFS that are also required under the new Safeguards Rule.
Sure. So the third-party oversight component in general as a whole, for organizations that don't have a program to assess third-party vendors or service providers, that's going to be kind of a long-tail process to get that established in an effective way to meet the requirements. In some cases, as I mentioned on earlier slides, the encryption of data at rest can be problematic, and finding effective other mitigating controls that both the final rule and DFS allow for encryption of data at rest may take some time because you need to not only devise that, implement that, but you need to test it to show that it's effective. And then multi-factor authentication. We've been pushing that in the security business for many years now, especially with the proliferation of cloud-based email use being as prevalent as it is now. MFA, there's still pushback on multi-factor authentication for those users that essentially go into an office and sit on a corporate LAN segment within the office. But the final rule from the FTC doesn't make any provision for that, unlike New York DFS that does. You need MFA according to the FTC final rule pretty much across the board for anybody that accesses data.
Yeah, and I think I'll just point out if you're a depository or have a depository somewhere in the enterprise and you've been dealing with the FFIEC guidance here, which dates back all the way to 2001 in terms of multi-factor authentication, that was just recently updated in the fall. So there's a lot of guidance on MFA and how to implement it and where it might be expected. Shawn, one difference definitely between the way New York DFS operates and the FTC is that historically the FTC is less likely to post FAQs on the website. DFS has done this for the cybersecurity regulation, and it's been a really important part of their process. How helpful have you found those FAQs? And I guess I would note that they may be helpful guidance, but the FTC, even if the language is the same in the FTC's safeguards rules under DFS, is not bound by any of those things, but they still may be useful guidance. Do you have thoughts about that, Shawn?
Yes, I think the FAQ process can be a big help, and I know it was for the New York DFS rollout because it addressed a lot of the common questions that people were asking. And I think it would be helpful if the FTC that approach and produce some FAQs. Certainly in the third-party oversight area, when the OCC issued its new guidance on third-party oversight in 2013, that they followed that with 3 FAQ releases, which was extremely helpful because that piece of regulation from the OCC kind of a complete rewrite of what they expected from examined institutions under their rules relative to what they expected in third-party oversight. The FAQs were hugely helpful there. So I am a big fan of those, and I think it's something FTC should consider as part of this final rule.
Okay, thanks. Quick question for Luke. So New York DFS has a dual mandate. They protect consumers, and they're also concerned with safety and soundness of the regulated institutions. The FTC is more explicitly a consumer protection agency and doesn't have as much of that safety and soundness mandate. Do you think that might impact how the FTC may approach enforcement of the Safeguards Rule?
Yeah, thank you, Jim. And that's a good question. And I think the answer is based on the limited data that we have. I think it is a fair assumption that before pursuing enforcement, the FTC is going to look to the effect on the consumers, the effect on the public of the actual violation. In the New York DFS cases that we've seen, certainly with respect to the most recent ones, which focused again on phishing attempts, there really wasn't a detailed analysis of the consumer impact of the violations. It was more, the focus was much more on, as I said earlier, whether the entities complied with their own internal procedures, whether they adequately investigated and assessed the risk, and how quickly they were actually able to fix the issue, which in those situations, according to the department, quickly. The FTC's most recent enforcement action didn't delve too much deeper into that, into the consumer impact, but there was at least a nod to the fact that the information that had been left open or left accessible to the public had been accessed. I think it was in excess of 50 times, including by foreign agents. So there's definitely a hint that that at least reviewing the consumer impact is going to be more of a focus of the FTC's enforcement than the New York DFS.
Yeah, and one practical thing I think as well that's a difference between not the substance of the rule so much, but as to how the difference in the nature of the regulators between the FTC and DFS is this annual certification requirement. In New York, under the DFS cybersecurity regulation, entities are required to certify annually their compliance with all of the applicable requirements under the rule. And so you can't file a certification if you are partially in compliance. The DFS has been very clear about that. But what that also provides is DFS has a roadmap to exactly who's complying and not complying. They know exactly who they regulate because those entities have a certificate on their wall that they are regulated by DFS, and they know who they've gotten the certifications from. Whereas that's not true with the FTC. The FTC, very many entities that are FTC regulated as financial institutions never interact with the FTC. Hopefully they don't, because the FTC would generally would interact with them by suing them. So the way that compliance comes about might be more in the nature of complaints or potentially security incidents. That's how it looks. And so it operates a little more like the Massachusetts Data Security Regulation in that respect. So with that, I would note that we are at time. I would like to thank everyone for attending today. Please fill out the survey on the site here, and we will look forward to talking with you again. The next one of our webinars, which we were trying to hold these about every month or so, and so we look forward to talking with you again, and certainly let us know if you have follow-up questions or would like to discuss any of this stuff further. And thanks to all of our panelists, particularly Shawn Malone of Security Diligence. Thank you, and everybody have a good day.